Hi, Hector Quiroga here with the Quiroga Law Office. Today I'd like to talk to you about depositions. What is a deposition? How do they work? And what you can sort of expect. If you are being deposed and you don't have a lawyer, you want to secure one right away because it's important for you to have representation in that process. Typically, though, if you are going through litigation, then deposition, you probably should have a lawyer at that point. You're already represented by our office, and so this video should kind of give you a little bit of an expectation of what you're about to see. A deposition is one tool in an attorney's tool bag on which the attorney can seek to better understand the other side's point of view. So I can call a witness to deposition, and you can ask questions of that witness. Typically, it's the opposing side that you're calling, and they are compelled by court rule to appear at this deposition. Depositions are a basic questionings about the matter. Okay? And typically, in personal injury cases, we talk about how did the accident happen, and then what kind of damages occurred, what kind of medical treatment exists, how is the party doing now, and how was the party doing before the accident. So there's certain range, there's certain gap of time that we ask about. Now there are certain objections that a lawyer can use, but typically it's not what you see in the movies. It's not this objection. The lawyers talk. You object. Objection. The question is leading. Go ahead and answer. That's what you tell my clients. You have to instruct the witness to go ahead and answer anyway, if they can, and if they can understand the question. It's very common the objection gets preserved on the record that way. If ever we go to trial and the answer to that question becomes an issue, you can then have the objection pulled from the record and then have the judge rule on that, whether or not that answer should be valid or not. That's if you go to trial. So, but at the deposition table or at the deposition time, the witness still needs to answer the question. There's a few exceptions for that. Attorney-client privilege, for example. What did your lawyer tell you? That's seeking privileged information, and at that point, I would instruct my client not to answer the question because it's privileged information. But that's one of the exceptions. There's a few others, but they're very, very minute. What you can expect at the deposition is you can expect professionalism. Yes, there is a lawyer on the other side, and they probably either sue you, or you're or is the person that are trying to hold recovery for your injuries and damages, or is somebody in a dissolution who is trying to take your income or your assets away from you. But the lawyer is a professional, and it should be professional at all times. There is a few attorneys in town who may not be as professional, but for the great majority of the Spokane bar, I'm telling you, it'd be a cordial situation. It doesn't have to be adversarial in the way we understand it. The lawyer is there to do their job. They're going to ask you questions. The other side may or may not be there. The other party may or may not be there. They certainly have a right to be there if they want to be there. Sometimes they don't want to be there. Sometimes they do. Okay, and there will be a court reporter. Okay, court reporter typically is paid by the party who asked for the deposition, and the court reporter is going to be taking notes of everything that is said. So it's important that that everything you answer to is audible. Typically, in the instructions to the deposition, we ask you to answer yes, no. Don't answer because when you read on a transcript, you don't know if that was a yes or no. Did you stop at the red light? If you read you don't know if that's a yes or no. We don't know that. So answer audibly and answer to the best of your ability. If you don't know the answer to something, you can say I don't know. You gotta be careful though, because if you start saying I don't know, then your credibility is destroyed. You want to make sure you're truthful with all of your answers, and you want to make sure that you have credibility on that. Truthfulness, to the best of your ability and to the best of your understanding, answer that. That's that. Typically, the other side or your own attorney will ask you some follow-up questions, a cross-examination, if you will. Most lawyers don't go too much into detail at this stage. Sometimes the lawyer say, I have no questions, because there's no point in doing a short cross-exam or anything like that. Sometimes it's not worth it to put more evidence into a court record that you don't need, so a lot of lawyers have the view that maybe a cross-examination is not the best thing. I go with a case-by-case basis, and I figure out maybe it's important to clarify this or not. That's it. That's what a depo is about. Now, depositions could have a very big impact on a case. What you say or how it can be interpreted can be very important for a case. So it's important that you have a lawyer represent you there, because although it shouldn't be stressful on the sense of the mechanics of it, it is important for a case. It may not do anything for the case. It might just simply be done, continue towards a final resolution at trial. But it could also instruct the parties to settle, or you can learn things that about the case, so the other side can learn things about the case that is either making them worry, want it settled, or may not think that they have a better case than they thought. So it's important to have an attorney there. It's important to prepare a little bit, talk to the lawyer about what is going to be, what expectations should I have about my deposition. This is just a general video about depositions in general, but your specific depo should have a little bit of talk with your counsel as to what is about to happen. Depositions typically happen after interrogatories are given. Interrogatories is yet another tool in an attorney's tool bag, which is just a set of questions that are written, and you have to answer them truthfully under the penalty of perjury. So what happens is you get the discovery back, you get the interrogatories back, the lawyer looks through them, and if there are questions or clarifications, you can ask that in a deposition. That's kind of how it works. So that's what depots are about, the general rule. Again, if you have questions about your depo, or if you are being deposed and you don't have counsel, please give us a call, 509-927-3840. We might be able to help you through that process. So again, I'm Hector Quiroga with the Quiroga Law Office, 509-927-3840. Thank you.